If you're married and you're going to go meet with an attorney for the first time to talk about your will, there's 4 things you want to make sure that you and your spouse talk about before you get into that attorney's office. My name is Andrew Ayers. I'm an estate planning lawyer with offices in Edina, Minnesota and New York City. And today we're going to talk about a little pre-meeting preparation that you can do with your spouse. Some discussions that's good to have before that meeting so that you're on the same page and you have an idea to help that estate planning attorney craft the right plan for you and your legacy. Now, the first thing we're going to want to discuss is what happens when one of you dies. We don't have to say who we think it's going to be. We don't have to think you're going to outlive your spouse or have any awkward discussions about that. However, you do want to have some kind of a plan for what happens when the first one of you to die dies. Do you want everything to go to your spouse? Do you want some to go to your spouse and some to go to your children? Depending upon your age, what do you want to have happen if one of you remarries after the other one dies? And as we're looking at all these different scenarios, they can lead us to the overarching question which is, do you want to have a will or do you want to have a trust? You can have a will-based estate plan, you can have a trust-based estate plan. And if you have a trust-based estate plan, there's still a will built into that component. But it's important to understand these basic questions so we can figure out whether you really need just a will-based plan or do we want a full estate plan with a trust built into it. The second thing you want to talk about is if you have children, what are you going to do with their inheritances? Is it going to be equal for each child? Now, if you have more than one child, you're not playing favorites, but especially if they're adult children, maybe one of them is a little more financially responsible than the other one. Maybe only one of them should get their money outright and the other ones should be held back in a trust. Depending upon how far along in life your children are, maybe you already have grandchildren. Do you want to take a portion of your child's share and put it into a trust for your grandchildren to use for education or a wedding or other purposes down the road? Or do you want to create a trust to entirely handle all these issues? So the two of you can have a joint trust where there's money being held for your children and for your grandchildren and can have a variety of other provisions. And while you're thinking about your children, if they're under the age of 18, another thing to think about going into that first meeting is who would be the guardians for your kids if they're under 18? Who would take care of them if both of you were gone? Third thing we want to think about is what's going to happen under your will? What's in that will? And the first question, and it goes back to the issue of guardians and trustees as well, is going to be who's going to be that personal representative, the administrator of your estate? Who's going to be the best person to handle all the responsibilities that come with winding up your estate after you're gone? And a corollary to that's going to be, what are we doing with our property? When you have big property, you may have specific bequests, but when you have smaller property, things in the house, there's 3 common ways that I see people divide them up. First way is just let the kids figure it out. So after you're both gone, the kids can go in the house and figure out who wants what. The second, you can create a little document that you keep with your will. In some states, you can do a personal property memorandum that says specifically what item goes to which person. If you have family heirlooms, maybe you want to go back to your siblings or your cousins, we can have that laid out. And the third way, if we have serious assets, serious personal property, and we're worried about how our family is going to divide them up after we're gone, we can actually put those distributions into your will. They're called specific bequests, and they say specifically, when I die, my brother John gets X, Y, and Z. Or when I'm gone, my child Steve gets this, my daughter Mary gets this. Fourth area we're going to talk about is not necessarily in your will, but it's a general part of your estate plan, and that's going to be powers of attorney. And when we're looking at powers of attorney, there's 2 main areas to look at: your health and your financials. So your power of attorney would come into effect if you become incapacitated. Let's say, for example, you're both in a car accident and you're being kept alive on breathing machines and you're unable to speak for yourself. That healthcare power of attorney will allow somebody to be able to speak and make medical decisions on your behalf. Now, most married couples will come to my office and say, I just want my spouse to be the person to have that power. And that's fine and dandy for a first person, but what if you're both in that car and you're both in the hospital? We want to have at least 1, if not 2 or 3 other people that can be there and be involved to make those decisions. Now remember, if your children are under 18, they shouldn't be the ones making those decisions. We want to make sure we have an adult. The same principle goes then for the financial power of attorney. So let's say you have assets, you own rental properties and you have to manage them and you're bringing in income and You have to manage your bank accounts and pay your bills. A financial power of attorney will do the same as a healthcare power of attorney, but focused on your finances. Now, married couples often don't necessarily need a financial power of attorney as between their assets because their names are on both of them, and if one of them is sick, the other one can manage the business, manage your bank accounts, manage whatever else you have going on. However, if you're both incapacitated, that power of attorney can allow somebody else to make sure your bills are being paid and that everything's being taken care of while you're in the hospital. You don't want to let these things fall by the wayside because, missed mortgage payment after missed mortgage payment. Next thing you know, you're coming out of the hospital a couple months later finding out that they're trying to foreclose on your house. So these are 4 areas that we talked about that I think you should have a discussion with each other before you meet with that attorney. First, what happens when one of you dies? Do you need a will or a trust? Second, what are we going to do about the kids and their inheritance? Third, what should be in our will? What are we going to do with our personal effects and who would be the representative? And fourth, what should we do with powers of attorney? Who should be a financial power of attorney? Who should be a healthcare power of attorney? And they don't actually have to be the same person. If you're ready to get started, you can go to my website, andrewmayers.com. There's a red button that says Legal Strategy Session on the front page. Click that and you're taken to my personal calendar. We can set up a legal strategy session. It's about a 15 or 20 minute phone call. We're not going to go over your name and your address and your date of birth and all that. We're going to talk a little bit about what you know about the process and make sure we get your questions answered so you can have a plan for taking the next steps forward for you and your legacy.